just want to start out by saying that no one detests child molesting any more than me. No one. And that's evidenced by the fact that I've tried 3 of the worst and most serious child molesting cases that we've had up here since my term as prosecutor. And on all 3 cases, we got a conviction. In all 3 cases, the defendants were sentenced to 35 years or more. Here today to answer questions, we've had a couple inquiries about a case entitled State of Indiana versus Bradley Locke. It's a child molesting case. The inquiries are, why did Bradley Locke get a plea agreement such as he got versus the results that you've heard of the 3 jury trials I described previously? There are a number of reasons, and I want to make those public now. Obviously, ethically, we are not allowed to discuss cases until they are completely resolved with the public. In the Bradley Locke case, a very young, brave girl came forward and recounted facts that constituted child molesting. We had no forensic evidence, no physical evidence. Based upon her recounting these facts, we filed charges. As the case progressed towards trial, our victim was unable to recount a lot of those same facts that she stated at the beginning of the case, which put us in a position that at that time there was a very, very slim chance that we would have any success at trial with a conviction through a jury. You have to be able to prove the elements of the crime. In this case, we had a victim who would be establishing those elements and now was not saying all the facts needed later on in the case that she said at the beginning. In addition to that, we dealt with the father and the grandfather of the victim. They made the decision, and that decision weighted some on us, and especially in light of the fact that we weren't going to have a very good success rate if it went to trial, that it would not be in the victim's best interest to proceed through a trial and put her through the trial. So the dilemma on our side is now we realize the chances of success of getting a guilty verdict are slim. And now we're being told by the family that they feel it will harm the little girl more than help if we force her to go through a trial. Based upon those factors and the victim's consent, the victim's family's consent of offering a plea agreement, the plea agreement was offered. And when you think about it, what are our choices in this case? We could have decided, okay, a little girl telling us things is not enough evidence, we're not going to file charges, so nothing gets done. Or we could have went to trial, but realizing our chances were very slim, and if the defendant gets found not guilty, nothing's done. As far as no penalty, no protection. But in this case, at least we're able to negotiate a plea where the defendant's not allowed to have any contact with the victim, and he's going to have to register on the sex registry, so the whole world's on notice that he's a sex offender. And he's got a felony conviction, so if anything like this happens again down the road, that will help us enhance a more severe penalty later on. So I just wanted to make sure that the public understands the facts and the reasoning. If you hear something like this and hear that a person is charged with child molesting, and then you hear why would he have gotten something that easy or that light as far as a deal, ask. I mean, there obviously are definite reasons why it occurred that way. Otherwise, we've taken a hard line approach. Either you're going to prison for 35 or 40 years, or we're going to trial, and we'll get a conviction, and then you're going to prison for 35 or 40 years. If anybody has any questions, I'll be glad to answer those.
I have 2. The first one is, do you think the girl was telling the truth from the get-go?
We definitely think she was, or we wouldn't have filed the charges. And you know how this goes. We're dealing with a very young child, though. And then as time went on, I mean, you think about this, I doubt if it's something a victim wants to remember all these things. So I don't know if in her own mind she just blocks out bad things now. But for whatever reason, you know, when we got closer to the trial now, she was not able, or was not saying all of the same things that she said in the beginning.
What about statute of limitations? Could you have just sat on the case and maybe released him, or?
I mean, I guess that's something you could look at. I think it would be very difficult. It's been our experience that the longer a case sits and goes on, then it becomes even harder because, I mean, you're going to say, well, you remembered 4 years later as opposed to when it first happened?
Well, I guess where I'm coming from is maybe the victim gets older and it, I don't know, gets a new dose of bravery. I mean, sometimes with age comes wisdom and the ability to maybe face something like this, or maybe not. I mean, it's just kind of a hypothetical question.
Let me make a distinction between what you said. Statute of limitations involves when we can file the charge. Once we've made the decision to file the charge, we have certain requirements under this Indiana Criminal Rule 4, which are the speedy trial requirements. At the very beginning of all of this, there was a lot of detail, there were a lot of facts that made what we believed a very strong prosecution, even though there was no physical or forensic evidence to corroborate the incident. Given that circumstance, once the decision to file the charges was made and the charges were actually filed, we're no longer under a statute of limitations, we're now under a speedy trial.
Okay.
And so we've only got 365 days from the date that we filed the charge, minus that time is not counted against us, anything that the defendant does to continue that. So, but once the decision to file the charges were made, we couldn't, as the state, continue the case out in
There's
that
no
fashion.
going back.
Right.
Okay, gotcha.
Right.
Okay, well, you got a felony conviction on this defendant. Can you guys talk about the likelihood that you very well could be dealing with this defendant again in a sexually based offense?
I mean, I don't know what you're getting at there.
Well,
I mean, anytime anybody commits this kind of offense, obviously there's, you know, more
What's the likelihood
that they're going to
repeat offender?
repeat, yes, as opposed to someone that's never done that. I think statistically that's a definite. And that's why, even more the reason, we wanted to make sure we got a conviction. We wanted to make sure sex registry, those kind of things involved here. But you know how it goes. I mean, if we'd have came back and said, okay, you plead guilty and you're going to get 20 years in prison as opposed to 35, they've got an attorney too. I mean, you know, and we'll take our chances. I mean, we'll try to beat this. And you also have to understand too, I mean, we kicked this around with the victim's family. So trying to figure out what's the best we can get under the circumstances without them deciding they're better off to roll the dice, and then they very well could get nothing too.
I mean, I'm not trying to play psychologist here, but you don't seem entirely happy with the plea deal. I mean, you're pleased with what you could get, but then at the same time, there's that pit in your stomach that,
No, I'm not.
Oh, you're not?
No, I'm not happy with this. I mean, you know, but unfortunately, we got what we got to deal with. I mean, if I go to a gunfight and I don't have any bullets in my gun, what's going to happen? So, I mean, do I believe this occurred? Yes. And would I have liked to have seen that we could prove our case and go forward and had a likelihood of success? Yes. But unfortunately, that's not the cards we ended up being dealt. So we had to deal with it and adjust accordingly. But I'm not happy with it, no, at all. I agree with anybody that wants to say that's light, but under the circumstances, it's our opinion, and several of us looked at this, that that's the best we were able to get with the cards we were dealt.
That's all for me. Thank you.